This is a Data Privacy Detective, and this is our monthly report on news from last month. So we're going to look at August 2024, the hottest month on record for high global temperatures, at least as far as we know, and a lot going on in data privacy too. So let's jump right into it. And like every month, Yugo Nagashima and Brian St. Amour are my colleagues. They're both digital and data privacy attorneys. And thanks for joining us, Brian and Yugo. Now we're going to start with the Netherlands. Yugo, what's the news from the land of the Dutch?
Well, Joe, big news from the land of the Dutch in Europe. Uber was fined 290 million euros. That's approximately $324 million for those.
That's a lot of non-taxi rides, isn't it? Boy, a lot of money.
Yeah, it's a little expensive for a taxi ride. Fines for transferring personal data of European drivers to U.S. servers in violation of the GDPR. I want to elaborate a little bit. So GDPR basically controls the transfer of personal data from one country to another or one region to another. And U.S. currently, if you're in something called the data privacy framework, you would be considered adequate, that you wouldn't need to basically have special contractual language. But
kind of a safe harbor approach, right?
Right, a safe harbor approach. But up until late 2023, because some of the decisions coming out of Europe, U.S. was not considered adequate. And that's the time period we're talking about here.
Right. Now, Europe enforces this through various data protection authorities in different countries. So what did the Netherlands data, the DPA, claim?
Yes. So according to a privacy watchdog and information that I understand, Uber transferred personal information, including ID documents, that's like driver's licenses, passports, tax licenses, criminal records, medical data, and location data of European data subjects. And as those who have listened to our podcast a lot, those are very sensitive data, right?
Yeah, they're highly sensitive,
yeah. To the United States over a 2-year period. Specifically.
Okay. But wasn't there a prior data privacy framework? I mean, what's the issue here?
Right. So I want to talk about that. The Dutch DPA, right, the Data Protection Authority, claimed that Uber failed to appropriately safeguarded data transfer to the United States. And of course, well, we know from the news that Uber did have, it did have the safe harbor for the EU-US data privacy framework, and before what's called the Privacy Shield. They did have
you called it the Privacy Shield. That ended, in the middle of 2020, I think.
That's right. And
at least by the European court. The court struck it down, saying not adequate, something like that. Yep.
It was because of the Schrems II decision. And so if you remember, the European Court of Justice issued an opinion invalidating the EU-US Privacy Shield on July 16th, 2020. And at the time, Uber was relying on the Privacy Shield framework. So, it isn't like they didn't have anything for the lawful cross-border transfer of personal data. But the Dutch Data Protection Authority claimed that Uber did not change its practice to adopt, an alternative method of safeguards, right? And those are.
Okay. So it didn't adopt the standard contractual clauses in that about 2-year period. Is that kind of the essence of this?
That is right. It didn't do the SEC or binding, binding corporate rules. So that was the issue here.
Okay, well, how's Uber responding to this claim and a huge fine?
So Uber is appealing the decision by the Dutch Data Protection Authority.
Well, what's the takeaway? I mean, of course, Uber is something like, well, we tried, we were caught in the middle and so on. But, what's the takeaway to businesses generally?
So I think the first important thing to note is the U.S. companies must take data protection decisions coming out of the European Court of Justice, EJCU, very seriously, right? So let's talk about Schrems II. Once Schrems II invalidated the Privacy Shield, what Uber should have done is, instead of saying, hey, let's wait until the next, data privacy framework coming together between the US and Europe, they should have said, hey, the opinion says it's invalid. We need to implement the measures that's allowed. And the measures were clearly stated in Schrems II decision, which was binding corporate rules or standard contractual clauses, the alternative data transfer mechanism. They didn't do that. And I think companies think, hey, we can just wait out the period. We already have, for example, an older version of a privacy framework transfer mechanism, right? You can't always rely on that, because this case shows you that there are data protection authorities in Europe that will say retroactively, yes, you have the privacy shield, now you have the data privacy framework, but what about these periods in between? And they'll retroactively fine you. And this is a great example where people need to be taking every decision coming out of the CJEU seriously when there's a data protection decision.
And they better have a backup plan. Well, let's get an in-house attorney perspective. Brian, what are your thoughts?
Yeah, I mean, Yugo, as I hear this, I'm just kind of interested in your perspective on whether we can just rely on those EU-US framework, or should we be considering contractual clauses to ensure protection within our agreements and structure?
Yeah, that is a great question, right? Because right now we have a working data privacy framework. That said, for those listeners who've been listening to the podcast, we do talk about Mr. Schrems a lot. Max Schrems is planning another lawsuit to take down the data privacy framework, and you never know when it's going to be invalidated. Until the CJEU says it's valid, you're protected, I think companies in the US and Europe should be, especially to transferring data across borders, should really consider the alternative mechanisms such as standard contractual clauses in tandem with the data privacy framework. It's a little more work, but I think it's better than a 290 million euro fine. So that's what I would suggest.
At least a backup plan. Well, let's turn to Minnesota. Now, that was in the news in August. We have a vice presidential candidate on one of the two big party tickets from Minnesota. And so, Brian, how's Minnesota in the news about data privacy?
Yeah, so I mean, kind of following the trends of the fact that we have this huge gap in the United States of no federal data privacy law, states continue to add new laws, kind of starting back with California's Consumer Privacy Act, or CCPA, back in 2018, and Minnesota is joining the fold.
Okay. Well, is it just kind of a copycat of everything else, or how does it fit into the trend we're seeing in about a third of the states now?
Yeah, so like you're seeing in, I would say, a vast majority of the states are kind of falling in a very similar flavor. I mean, I almost describe them, they're all ice cream, right? Not necessarily a specific flavor of ice cream, but at least we know they're all as sweet and they're all, along those lines. And so this law is going to provide privacy rights to Minnesota residents, and put restrictions on businesses and organizations to actually handle Minnesotian, personal data, and most covered entities will have to comply by July 31st of next year. But those post-secondary institutions or your universities that are regulated by a different government entity in Minnesota have until July 31st of 2029 in order to make sure they comply with this law.
Complicated details. Maybe we'll get a federal law someday. We'll see. But what exactly does this law apply to now?
Yeah, so this law will apply to entities that conduct business in Minnesota or offer products and services targeting Minnesota residents, and they have to meet certain thresholds. Those include, controlling or processing the personal data of at least 100,000 Minnesota consumers, or deriving more than 25% of their gross revenue from the sale of personal data while processing data from at least 25,000 Minnesota consumers. So this law is really also designed to apply to technology providers, so that contract with public education institutions. So that's where it's a little bit different on the Minnesota side.
Yeah, some peculiarities. Well, are there any exemptions?
Yeah, so the law doesn't apply to government entities, tribes, or insurance companies. And then there are also kind of some data type exemptions. So protected health data governed by HIPAA, data subject to the Graham-Leach-Bliley Act, and notably, nonprofits are not exempt. So this does deviate from some of the states that we've been seeing lately. Small businesses, as defined by the Small Business Administration, are exempt, but they still need to obtain consent before selling consumer-sensitive data.
Interesting. And what rights do consumers have under this Minnesota law?
Yeah, so a couple key rights come into play with this law. They include the right to confirm whether the controller is processing their data, the right to correct inaccurate data, and the right to delete personal data, with some exceptions, and then the right to data portability and the right to obtain a list of third parties whom the data was disclosed. So consumers have the right to opt out of the targeted advertising, the sale of personal data. So a lot of those things that you see in most of the other states
Yeah,
will
very
apply here.
common. Yeah, very common. Well, that's comprehensive. How are organizations expected to respond on these consumer rights issues?
Yeah, so they'll have 45 days if they're acting as a controller, to respond to the consumer requests, and they have to establish that process for appeals of denials of those requests. And then organizations using AI or automated processes that affect consumers will need to comply with specific requirements around profiling. So this includes allowing consumers to question profiling results and request reevaluations of decisions made through automated processes.
Hmm. Well, how about obligations for businesses about data handling?
Yeah, so the law has, a number of kind of significant compliance obligations, and this covers, your data limitation, meaning controllers or that company that is responsible for the data has to limit the collection to only what is necessary. Sensitive data where controllers need consumers to consent to process it. They have transparency and notice where clear privacy notices must provide, which is again very similar to most of the other states. And then finally the safeguarding, which involves maintaining reasonable security measures. And that I think is an area of all of these state laws that'll be one to watch, is what exactly is reasonable as we continue to head down this path.
Yeah. Well, how about enforcement? Private right of action?
Yes.
How was that addressed?
Yes. So the good news, I guess, and depending on which side, good news, bad news, but the positive here for companies is the only enforcement is exclusively through the state attorney general's office, which means there's no private right of action. And there's also a temporary cure period that will kind of give almost a grace period into July 31st of 2026. So some other states, that lack of private right of action, this is kind of staying closer to the majority. And so we just have a handful of states that are in that private right of action space.
Yeah, that's right. They're in the minority on that. Yugo, any questions for Brian about Minnesota?
Yes, Brian. Big picture, I want to ask you a question. Do you think Minnesota's privacy law is more of a follower law, as we see with Virginia and Connecticut, or is it more like California or Washington State, where it's a unique privacy law? How would you put it in a box? Which box would it go into?
Yeah, and I that's where I think Minnesota is definitely a follower law. There's some specific nuances around not exempting nonprofits and some areas that maybe make it a little bit different than some of the trends lately. But I'd say overall, you're seeing this to fall in that 80%, largely tracking kind of the GDPR type approach.
At least American style. And well, I'll tell you what, let's turn to data brokers. Now, sometimes news is this happened, somebody got sued, something happened. But sometimes news really kind of occurs like a kind of an ocean current. It just changes, and then you notice it's changed. And that's really what happened in August with data brokers. And what became public was what some called the biggest data breach in history. Now, I covered this in episode 180 of Data Privacy Detective. And what happened there was a data broker that had collected huge amounts of public and non-public information was itself hacked. And then a cyber criminal offered this huge data trove, including far more than 100 million U.S. Social Security numbers and other personal information for sale on the dark web for only $3.5 million. Get it now, a bargain sale. Well, that's going to lead, no doubt, to unfolding risks to millions of people. Well, this underlines the nature of digital data. If you think of your personal information as your property, you ought to have a right to decide what happens to it, right? Well, you provide it to government to get a driver's license. You provide it to private companies, banks, and so on. healthcare providers to get their service. But your data doesn't just sit there and totally protected in a cocoon. It gets shared, it gets sold, it gets hacked, it gets transferred to people and organizations you've never heard of. This is the nature of digital data. And data brokers are these companies that collect huge amounts of information about people. Now, much of that comes from public sources, but others information comes from non-public sources, and then they use it to offer background checks and other perfectly legitimate services. But they also share it with others and sell it to others. And like in this case, the database can be itself hacked and then misused by criminals. Well, this leads to the point that digital data isn't at all like tangible property. Digital data, in a way, never really disappears once it's released into a data stream. And your personal data ends up in places that are unknown to you, unapproved by you, with no control by you. And so you're subject to identity theft and the stealing of your money and your reputation being ruined and exposing your whereabouts and your driving habits and so on in ways you're not even aware of until suddenly damage hits. Well, you would think that data brokers are strictly regulated to protect against hacking and misuse of your personal information. Well, that's not so right now. They're virtually unregulated. Not until very recently did any U.S. state even require data brokers to register themselves. And there's no federal or comprehensive U.S. law or regulation that governs data brokers. Some hold vast amounts of information about us, even though we've never heard of them. So the August news is this: the spotlight is now on data brokers, and more basically on how society should regulate them, how personal data spreads, and how can it be controlled and yet balance the interests of companies that gather information for totally legitimate purposes, often from public sources. Now, an important August development was the August 29, 2024 call to action by a member of the Forbes Technology Council, by Aaron Mendez. He's the CEO of Privacy Hawk. Aaron issues a call to action, and he points out how data brokers are virtually unregulated and how that makes it easier for scammers and identity thieves to profile us and our family members that will then go and commit fraud and theft. So data brokers, as I've described, are dealing with our personal information really without our knowledge, certainly not our consent. And so Aaron asks this compelling question, quote, if a consumer doesn't want a company storing any of their data, why should that company be allowed to? Close quote. Now, that's a question to regulators, legislators, and businesses that want to be in good standing about how they do things. So the news from August is that maybe the largest data breach in history, if that's what it was, and a call to action like that of Aaron, put the data broker industry front and center now in data privacy. That's going to impact businesses that collect and share data. It's going to force a review of whether information we share with government should be handled more securely, kept private in a better way, force a decision on whether each of us has a right and the ability to control our personal information as it spreads and gets shared and sold. And it I think will require a rebalancing, both in public and private sector ways, of how personal privacy is valued in e-commerce or not. In other words, as Sherlock Holmes or Dr. Watson might say, the game is on about data brokers. Brian, Yugo, your thoughts?
Sure. I am very much curious as to how the biggest data breach involving very sensitive information affecting a lot of us, if this has a large impact on a large population, whether currently, right, the US system is we opt out. But GDPR, the concern has always been opt-in, right? Opt-in consent, because there's a history in Europe where you have this espionage agencies and people really suffering from their personal data being leaked or being passed on to someone else. So this may be a tipping point of, how, and I mean, we've already seen the cultural shift of how important privacy is ever since the GDPR and the CCPA. And this may be another data point where it's going to be a tipping point where more and more the US may think, hey, maybe we have to get an opt-in consent because like you said, Joe, if we have an unregulated industry of data brokers who can just take our sensitive data and pass it along, it's going to have a large impact. And we're getting to a point where people will actually wake up to it and say, and people are already waking up to it, right? Because, privacy policies are changing, all these laws are coming into play, that the US may also become part of the bigger system of opt-in consent.
Maybe we will. Brian, any closing thoughts?
Yeah, and I just think this highlights something that we were talking about the last 2 months. We talked about the automotive industry last month, and now this. I think people are almost surprised at where their data is getting pulled in and being tracked. So I think that is, kind of just highlights the importance of needing a standardized law. And to Yugo's point, if it's opt in or opt out, but we do need to have that conversation, standardize, and then live within the confines of whatever's decided. I don't think it's something we can just keep waiting and seeing, because I think this isn't the last of these significant breaches.
Well, thank you both for joining. As always, I will close by reminding us all protecting your personal privacy and data begins with you.